IRA beneficiary designations. Very complicated area of the law, but important, because many times the client's assets in retirement plans and IRAs may be a very substantial part of their estate. And there's a great advantage in having assets inside an IRA. Income tax deferral. The assets can grow without income taxes being imposed until the assets are distributed outside the IRA. That's a wonderful result. However, one has to be careful in selecting the IRA beneficiary designations for these accounts. There are a number of themes which I would want to go through. Number one, many times it's much more simpler and easier to name individuals as beneficiaries of IRAs. Have your spouse as primary beneficiary and your children as secondary beneficiaries. That plan works for many clients. However, what if the spouse is a second marriage, or the kids are spendthrift or minor, and you don't really want these beneficiaries to have outright control of your assets? In those cases, you may consider naming trusts as beneficiaries of IRAs. But beware, improperly drafted trusts will ruin the deferral of the IRA and cause additional income taxes. We will discuss that next. Number two, IRAs as trust beneficiaries. As just discussed, sometimes it's critical to maintain control of IRA assets and not have your spouse or your children as IRA beneficiaries. You can name a trust as beneficiary and control how those beneficiaries will receive IRA distributions. Now that is a good thing, but let me tell you the downside. Many trusts are not drafted in accordance with complex IRS rules regarding naming trusts as beneficiaries. To qualify under these very complex rules, a trust must be either an accumulation trust or a conduit trust. These rules would actually take an entire seminar to explain. Suffice it to say, I understand the drafting styles to invoke these rules and satisfactorily name trusts as beneficiaries of your IRAs when that is appropriate in your particular situation.